back. As part of their rebuttal case, prosecutors want to show that the accuser's original police interview was consistent with his first story. It was videotaped back in July of 2003. Outside of the presence of the jurors, here's what the defense attorney Robert Singer told the judge Rodney Melville, according to the courtroom transcripts.
The first issue is on the tape that I watched yesterday afternoon. The court will allow the playing of the tape. I think that it's awful long. It seemed to me that, playing a half hour of it would be better than playing the whole hour. There's a lot at the beginning that's not even the boy talking.
Could I be heard on that part, Your Honor?
Yeah.
I watched. Of course, the prosecution made the motion towards the end of the day, and so I watched that thing in the middle of the night, basically, again to see what it looked like from the standpoint of playing it. And there's a tremendous amount of prejudicial material by way of police officers making statements that are absolutely inadmissible in court. On the other hand, to simply pick out, statements of Gavin in a vacuum that don't show that the police officer just said, you're really brave, we want you to do this, you're doing the right thing, and all the other things that they were saying, takes it out of context. I don't think that we're prepared. I don't think the people are prepared either to present a pared-down version, nor are we.
Well, it should come to no surprise to you that Judge Melville ruled the videotape does come in, but he suggested the prosecution, per his comments you just heard, only use about 30 minutes of it. Now, does it sound like the defense plans to start this trial all over again?
Now, with regard to the court's ruling that the tape is coming in one fashion or another, we had indicated that we would need to then have Gavin made available. We'd also like to have Janet, Dr. Katz, and Larry Feldman.
For a moment, I thought you were going to say something else, but that's fine.
Could you indicate what it is, and I'll add it to the list? So we'd like to have them available, and I understand they were the people's witnesses and that they would have a number to call them. We tried to find a number for Dr. Katz to give him a heads up, and we didn't have one, so...
All right. So I think that one of your people should call them right away this morning, right?
Yes, Your Honor, we'll do that. I want to tell the court that, first of all, we're not waiving any objection with regard to the materiality of whether it's appropriate.
That's fine.
The materiality, I suppose, of whether or not calling Gavin and Janet are back to the stand. Let's start at the beginning. Howard, the idea that now prosecution has presented their case, defense has presented their case, we're in what's called the rebuttal. That is the prosecution's opportunity to come back. And now they're going to play a tape?
The prosecution gets to present their case again. It's pretty clear what happened to me, of course.
What is that?
The judge assessed the situation, didn't like where the case was for the prosecution, and is aligning to start over again. That's the way I view it.
This is a huge victory for the prosecution. They get to have Gavin basically testify again without cross-examination, and that's why the defense wants to recall him.
Now, I don't want to get too technical here, but I think it's important for folks to understand what exactly the rules are here and how this fits as to whether it's really appropriate or not. Why is it that the prosecution isn't made to put all their evidence about the victim on when they first present their case?
Because that would be playing by the rules, and that isn't the way this case
Howard,
has
people are going to
progressed.
start thinking that you're a cynic.
No, I may be a cynic in this situation.
Okay.
I've said from day one, this judge has an agenda. I'm sad to say it continues.
But that is the way it should happen. The prosecution really should have put all this evidence on in the beginning.
Now, prosecution's case in chief.
Let's go to the next step.
This isn't a rebuttal.
What is the legal basis? What is a rebuttal, and what is it supposed to accomplish, and why isn't this type of evidence playing an interview, a police interview of the main complaining witness? Why is it not appropriate in your opinion here?
Because what should have been presented in rebuttal, and we do see some proper rebuttal in the prosecution's rebuttal, and that is what was presented in the defense case. They can rebut what was presented in the defense case. But
Right.
Gavin and the suggestions made about Gavin were not presented in the defense case. That's the prosecution's case in chief. That's when this stuff should have been presented. That's not rebutting anything presented in the defense case.
Okay,
I guess the argument, James, is that because the psychologist testified that sometimes kids fabricate at the urging of the parents, maybe that's an argument to put this videotape on. I don't think it washes, and I don't think that's why they're putting it on.
And that's the psychologist that the defense called.
Correct.
And Judge Melville, I think you're doing a good job no matter what Howard says. Next, will the king of pop bear it all? Yeah.
All right, the next issue that we have is the motion to admit evidence concerning Jordan. Do you wish to be heard on that, Mr. Snedden?
Mr. Zonin is going to handle that, Your Honor.
Mr. Zonin?
Your Honor, I think we've adequately stated our position in the pleadings. I can tell you that with regard to the relevance of that material, there was quite a bit of testimony that was presented during the course of the defense case about nothing untoward or inappropriate occurring in Michael Jackson's bedroom. And numerous witnesses who have testified to the fact that many children, particularly back in the 1993, 94, 92 period, who spent not just nights but weeks and even months in Michael Jackson's bedroom, in Michael Jackson's bed, and it was a completely non-sexual event. The fact that this child was able to give a description of a unique feature of his anatomy that could not have been known by him except for a very intimate acquaintance with Mr. Jackson is a very good circumstantial evidence of the fact that the relationship between he and at least that child was something more than casual and something more than innocent. Now, in that regard, we'll submit unless you have questions.
Okay, you got that? They want to have Michael Jackson's anatomy photographs come in to deal with the 1993 accuser allegation. As we move on, the defense argues that a courtroom anatomy lesson indeed is not required.
And the idea is, I think they've said in their pleadings, that this goes to the issue of whether or not Mr. Jackson was shy or modest. Now, that's not what Mr. Zonin just said when he got up here and argued. I think he shifted the argument a bit, if I'm not mistaken, and talked about things happening in the bedroom. They didn't offer, we can't just keep having a moving target here. They didn't offer it in their moving papers. They didn't offer it for that purpose. They offered it on the shy and modest purpose. So it would be 1101B evidence on kind of a collateral matter if it ever happened, but it didn't happen in this case in the defense. We went through and did a word search on the entire transcript, several different words, shy, modest, all sorts of things. We found one question that used the word shy, not even in this context. It had to do with whether or not a maid saw Mr. Jackson change his shirt. And the objection was sustained to that question. So it was never answered, so it didn't happen. What really they're trying to do, and I think that's what I heard Mr. Zonin just argue, is they're trying to argue this is 1108, and it doesn't meet the criteria for 1108. It doesn't meet the criteria the court set down, that it would be somebody directly observing something. So it would have the prejudicial effect of the jury considering it, obviously, for 1108 purposes, because it would be very shocking to see pictures of anatomical pictures and all that sort of thing.
All right, the cleanest language yet with respect to anatomy and photographs. By the way, the judge ruled that those pictures of Michael Jackson's anatomy having to do with the 1993 accuser, Jordy, will not be admitted into evidence.
I was there when the photographs were taken in 93. I know a lot about that situation. This was an appropriate ruling. As outrageous as I believe this judge has been during the course of this trial, I think that clearly would have been reversible error, and the judge made the correct ruling.
Yeah, but come on, Sean Chapman Holly. Howard says outrageous, but then he's not giving the judge credit when he makes the appropriate ruling, and he's made a lot of those in the defense favor. How can you have it both ways?
Howard, will you please give the judge credit for making an appropriate ruling?
The judge gets credit for making the appropriate ruling.
There you go, James. See?
We have to sit on Howard to get him to do the right thing sometimes. When we return, did the king of pop uncork too much Jesus juice? Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. On rebuttal, prosecutors tried to inflict some serious damage to the defense case. Assistant District Attorney Gordon Auchincloss calls former Neverland House Manager Jesus Salas back to the stand. Yes, you've heard that name before. Here's what he told the jurors about the Neverland sleeping arrangements according to the courtroom transcripts.
So, were you personally aware during this period of time, February, March, when the were visiting Neverland Ranch, were you generally aware of their location, the location that the boys slept in?
Objection. Foundation.
Overruled. You may answer.
Yes, I was aware.
And can you characterize, based upon your own personal observations, the On a percentage basis, the number of nights you would estimate that the boys spent in Michael Jackson's bedroom during that period of time that they were visiting in March and February of 2003.
Objection. Foundation.
Overruled. You may answer.
I would say they spent 90% of the time.
During that period of time of 2003, before you left your employment, did you ever see Michael Jackson when he was in an intoxicated state?
Objection. Beyond the scope. Improper rebuttal.
Overruled. You may answer.
Yes, I did.
How often would you see Mr. Jackson in a condition that you would characterize as intoxicated during that period of time?
Objection. Foundation. Relevance.
Overruled. You may answer.
It was quite a few times.
Did you ever see him intoxicated in the presence of his own children?
Yes, I did. Yes. Objection. Relevance.
Overruled.
Yes.
I didn't hear.
I said yes, I did.
Relevance, foundation, we'll explain it all to you in just a moment on cross-examination. Defense attorney Tom Mesereau throws everything but the Neverland kitchen sink at this witness.
Mr. Salas, you say you've seen Mr. Jackson intoxicated maybe 3 times during that period?
That is correct, in the way that I thought it wasn't safe for him and his family.
Was a nanny around?
Yes, it was.
In fact, there was a nanny around taking care of his children, correct?
That is correct, except when he used to take them to his room, yes.
Okay, and have you ever been intoxicated in your house?
Oh, yes.
Were your children there?
Yes.
Objection, irrelevant.
The answer is in. Next question.
Was it ever reported to you, Star told Angel Vivanco, you put some alcoholic beverages in my milkshake or I'll get you fired?
No, it was never reported to me.
Was it ever reported to you that Star and Gavin used to spit on employees when they rode the amusement park rides?
Objection, argumentative.
Overruled.
No, it was never reported to me either.
Was it ever reported to you that Star and Gavin would take their shoes and throw them at people from the amusement park rides?
Never heard that either.
Was it ever reported to you that Star and Gavin made an absolute mess out of their bedrooms in the guest quarters?
Not that I can remember, no.
Was it ever reported to you that Star and Gavin used to search the television for adult films?
Objection.
At their guest units?
Assumes facts, not in evidence.
Sustained.
All right, let's take a little time out and give our wonderful and loyal viewing audience a little primer, legal primer. Foundation. We've heard that objection a lot. What exactly does that mean? Who wants to take it, Professor?
I'm stuck on how inappropriate this line of questioning is, because this is not proper rebuttal. Some of it is, some of it is not.
Okay, why?
The issues about the sleeping arrangements and the intoxication, none of that was disputed in the defense case, such that this witness needs to be recalled in the rebuttal case. Now, with regard to what Jesus Salas should or should not have been told as a supervisor, that is proper rebuttal, because that did come out of the defense case.
All right.
So,
what about this issue of foundation? Define that for me real quick, Howard.
The foundation, very quickly, is you have to ask questions that show the witness would be in a position to have the information and testify. Interestingly enough, Mr. Mesereau, in my opinion, concedes Michael was intoxicated on more than one occasion in the house, and I thought it was a good point for the prosecution.
Oh, boy, watch out. Stop the presses. Can we do some kind of fancy effect? He made a point.
He's on a roll.
On rebuttal, the prosecution is going to thank Howard Weitzman, and they're going all out, especially since Team Jackson scored a major blow, or several really, when they rested. One of those blows came from the testimony of paralegal Mary Holzer, who represented the accuser's mother in her lawsuit against J.C. Penney. Remember that one? Now, don't forget, the David who Holzer, this witness, refers to is the father of the accuser. Remember the bad dad guy? That's him. Here's what the paralegal told the jurors about Janet's injuries.
And was it your understanding those photographs were to be used in the lawsuit against J.C. Penney?
Yes.
And was it your understanding that the photographs were supposed to show injuries inflicted on Ms. by J.C. Penney security guards?
Yes.
Did you ever have a chance to discuss with Janet those photographs?
Yes.
And what did she tell you about those photographs while that lawsuit was going on?
She told me that the bruises that were on her body were inflicted by David that night after the altercation at J.C. Penney's.
And what was your response to her telling you that?
Well, it scared me.
Why?
Well, I represent my law firm, and when a client admits to fraud, it's kind of scary.
And did you say anything to Mrs. in response?
Yes, I did.
What did you say to Mrs. about that?
I told her that she couldn't do that, that was wrong, and that, she needed to retract that, and that she needed to speak to Mr. Rothstein about it.
Did you tell her that was fraudulent?
I don't know whether I used that word. I told her it was wrong, that you can't do that.
And?
I was very upset.
And what did she say to you in response?
She said, well, don't say anything to anybody, because she was at that time in a custody battle with David, and that, I don't know. I'm sorry, I lost my train of thought.
Did she threaten you?
Yes, she did.
How?
She told me that David's brother Ray is in the Mexican mafia and runs drugs between Los Angeles and Las Vegas, and that she knows where I live because she had been to my house on several occasions, and they would come and kill me and my 9-year-old daughter.
Did this terrify you?
Yes.
Did you ever tell anyone at the law firm about what Janet had told you?
No, I did not.
And why didn't you do that?
Because she told me not to.
Did Janet ever tell you anything about her children being in acting classes?
Yes.
What did she say?
She told me she had them in comedy, stand-up comedy classes and acting classes. I don't know how far in detail you want me to go.
I do.
All the way?
I'll object to the narrative form of the answer.
Sustained.
What did Janet tell you about her children learning to act?
She said she wanted them to become good actors so she could tell them what to say and how to behave.
On cross-examination, Assistant District Attorney Ron Zonin concentrates on the photos taken after the JCPenney altercation.
In fact, all of those injuries that you saw depicted in those photographs were completely consistent with her being forced down to the ground by 3 or 4 different people who are either on top of her, using their knees to put pressure on the backs of her legs, the front of her legs, and on her arms and wrists. Is that right?
Objection.
That's what I believe.
Calls for speculation, lack of foundation.
Sustained.
Did you believe, based on your observation of those injuries, that they were perfectly consistent with what you were representing in your lawsuit?
At that time, I did.
Howard Weitzman, come on. How is it that a woman who works as a paralegal in a lawyer's office doesn't report a threat to her and her family by a client?
She should have reported it to the attorney right away. I think this is a good opportunity for the prosecution to show the defense has called a witness that may be suspect. That is their credibility. You know what? Janet either is a liar in the jury's eyes or she's not by now.
Well, nevertheless, this is devastating evidence against Janet. Even more, she lied under oath in a legal proceeding. She threatened to have David's brother do harm to her if she told the truth. And she put her kids in acting classes so that one day they could follow the script.
Well, maybe not. Certainly that is the testimony. I concede that. But this woman's a paralegal, folks. She should know to do something with this information. When we return, did the accuser's mother see Michael Jackson grow horns? Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. Paralegal Mary Holzer testified that the accuser's mom lied about her injuries in her lawsuit against JCPenney and threatened to have the paralegal and her daughter killed. But should a little thing like that really, a death threat, come between you and one of your buddies? Here's what the jurors heard according to the courtroom transcripts.
When did you last talk to Janet?
Objection. Exceeding the scope of cross-examination.
Overruled. You may answer.
She called me, I would say, about 3-4 months ago.
Do you know why?
She wanted to be friends.
What did she say?
I said I was very busy.
Did she say anything else?
She asked me to call her. She'd like to get together and maybe have a girls' weekend, and that she had just had a baby and she was remarried. And I felt like...
I'll object as to her personal feelings as irrelevant.
Sustained.
Did she say anything about this case at any time?
No.
Did she say anything about the JCPenney case?
Well, yes, she did. I rephrased that. Yes, she did.
Did she talk about the JCPenney case?
No, she talked about this case.
Did she remind you of her threats?
No, she proceeded to tell me that Michael Jackson was no longer her savior. He was now the devil.
This testimony, I think, is powerful, even though this woman didn't report, when you combine it with the forensic psychologist that the defense called to say, look, you got to look at, when you're making decisions about whether or not a kid is lying about an allegation like this, at the family.
Not only did she not report, I want to go right to the heart.
Sure.
She allowed a case to be settled and money to be paid when she knew Janet was lying. Her credibility could have and should have been destroyed by the prosecution.
And it was gone after, but not as hard as maybe it could have, Sean.
Well, maybe not. You know what? It doesn't matter because we have focused all of this time in the past several weeks on this family, and now with this judge's ruling, it's brought back to the heart of this case, which is Gavin's accusations.
Which is where it should be.
Well, and that is certainly true, but we still are at the mom. Did the defense make a mistake by putting this witness on? And she's got some big issues. Now reporting this, allowing the settlement to go through. She's got a fraudulent client, according to her own testimony.
I think it was a mistake. I think this witness's credibility could have been destroyed.
But it wasn't.
Well,
it wasn't.
That's for the jury to decide, Ms. Sean.
I guess you're right.
Well, so come on, Sean. It certainly could have been. This is not good stuff. Come on.
It's not good stuff.
How are you going to argue this to the jury? Yes, she says she was threatened, but, you know, she works in the law office, folks. She never bothered to tell anybody.
So
and she let her take the money.
Is she lying? And if so, why is she lying? Is it just to be involved in this case? What motivation does she have to go against her law firm?
But you know, what's good for the goose is good for the gander.
Unless she made all this up after the fact.
Yeah, we'll see. That's it for this week,
why?
folks. We'll leave it right there. Be sure to watch our exclusive coverage of the Michael Jackson trial, the weekend wrap-up show. When is it? Saturday, 10 a.m., right here on E! Now, you guys know that's not right. We'll see you.